now and press the bell icon. Never miss an update.
Right. This is the first Vasudha Sethi versus Kiran Bhaskar. It's a 2022 judgment. All right. And it talks about the maintainability of habeas corpus in case of child custody. Right. Okay. So it is a two-judge bench judgment, but it is important from family law perspective because it did talk about the habeas corpus in case of child custody case. It's not a very big judgment, like 24 pages, I believe. Okay. So what happened in this case was there was a judgment given by Punjab and Haryana court in favor of the Kiran Bhaskar. Kiran Bhaskar in this case is the respondent and Vasudha Sethi is appellant. Okay. So, but in High Court, Kiran Bhaskar was appellant and Vasudha Sethi was respondent. And the judgment was given in favor of Kiran Bhaskar. Okay. In Punjab and Haryana High Court. And in this case, Supreme Court also affirmed the same judgment of Punjab and Haryana High Court. So there are a few theoretical concepts that you should know. Otherwise, there is nothing that important in this case. There was a dispute between appellant and the respondent, right? Appellant is the wife and the respondent is the husband, okay, over the custody of the minor male child. And what happened was that then there was a habeas corpus that was filed by the husband, by the respondent number 1, for getting the custody of the minor in the Punjab and Haryana High Court. After that, there are certain, this is the brief issue, what has happened, okay, the dispute between husband and wife. Then what happened, the husband and the wife, the respondent number 1 and the appellant number 1, they were married in New York, United States of America on 13 January 2011. And the child was born in USA, okay, on 21st January 2016. All right, just a second. Okay, this is the table. Done?
Yes, ma'am. Thank you.
Okay. So they were married in USA and the child is a citizen of USA by birth and he's also holding a USA passport. But unfortunately, that child was diagnosed with some medical condition, hydronephrosis, and that required surgery. And in USA, they couldn't secure an appointment of a doctor for surgery. And they agreed, husband and wife, they both agreed that they'll take the child to India, okay, for that surgery. And then in USA, as child is the citizen of USA, so they have to give a consent, okay, consent for international travel, because the child was a citizen of USA with one legal guardian, and that has to be executed by and between the appellant number 1 and the respondent number 1. Okay, so which means either husband has to go along with the child or wife has to, accompany that child. So one of the legal guardian has to travel with the child, and that consent agreement, that consent for international travel, that has to be executed by both the guardians, husband and wife, or his father and mother, right? So that was happened on 4th of February 2019, and the consent was also recorded in that document, so that the child will travel along with the mother, that is appellant number 1 in this case, to India. The consent was executed for the period between 5th of February 2019 to 26th of September 2019. Okay, which means they have to leave USA on 5th February 2019, and they have to come back to USA again on 26th September 2019, right? The consent document recorded that, just a second. The consent document recorded that the child will be leaving USA. So this consent document recorded that the child will be leaving USA on 5th February and he'll be returning back to USA on 26th September 2019. Okay. And it was further recorded that any changes to this plan that will be discussed by both the parents, right? Then a certificate was issued on 17th September 2019 by the doctor in India, who was a pediatrics, saying that the child underwent a surgery on 14th March 2019, and he was also examined on 12th July 2019, and he said that the child is doing now fine, he's well. And the doctor, Indian doctor, he mentioned that the child needs to be reviewed 6 to 7 months post surgery, okay, along with a fresh ultrasound and renal scan. That's all. That's the what happened between both the parents and in India. After that, there's a litigation history. What happened? So here, it was the case of the respondent that the appellant had violated the international travel consent. Appellant means wife, right? Wife ने international travel consent जो था उसे violate किया. That's what respondent is saying. By not allowing the minor child to come back to USA by 26 September 2019, because that was agreed in the travel consent, international travel consent. And therefore, the petition was filed before the Circuit Court of Benton County, Arkansas, USA. Okay, so husband, he filed a petition in Circuit Court of USA, right? He asked for the primary care, control, and custody of the minor on account of his wrongful detention outside USA by the appellant, wherein interim order was pronounced in favor of the respondent. So he basically asked for the primary care. He asked for the custody of that minor child, saying that he's wrongfully detained outside of USA by the appellant. Okay. And the Circuit Court of USA, they gave an order in favor of the respondent. Then it was, the wife, she didn't pay any heed to the said order of the Circuit Court of USA, right? And that's why then the respondent approached the High Court of Punjab and Haryana, okay, and seeking a writ of habeas corpus to secure a release of the minor child from the illegal custody of the appellant. Okay, then the High Court, by the impugned judgment, decided, of course, in the favor of the respondent and directed appellant to hand over the custody of the minor to the respondent. Okay. Now the court went into analysis of all these contentions, whether the High Court judgment is valid or not, or what was done by the appellant is really a wrongful detention or not, and a few sections of family law, Hindu law. Okay. So the court is saying it is not the case of the appellant number 1 that there was even a discussion between the appellant number 1 and the respondent number 1 for the modification of the said consent till date. कोर्ट ने बोला कि इन दोनों के बीच में ऐसा कोई डिस्कशन ही नहीं हुआ था कि वो कंसेंट जो था इंटरनेशनल ट्रैवल कंसेंट उसमें कुछ मॉडिफिकेशन हो. ओके, admittedly the period of travel mentioned in the consent was not extended by the respondent number 1. इसीलिए वो जो ट्रैवल कंसेंट था उसमें कोई मॉडिफिकेशन नहीं था, ना ही उसका कोई एक्सटेंशन हुआ था. Then the appellant, that's the wife, she has not placed on record any medical certificate or opinion of Dr. Anurag Krishna on the present health condition of the child. So बेसिकली अपीलेंट ने कोई ऐसा मेडिकल रिकॉर्ड भी नहीं दिया था कि चाइल्ड को और मतलब उस बच्चे को और इंडिया में रखना पड़ेगा on the basis of his health conditions. Then the appellant have not placed on this is just a repetition. Just a second, sorry for that. So the court said that we'll have to proceed on the footing that there is no documentary evidence available on the record to show that the presence of the child in India for further medical treatment is necessary. कोर्ट ने ये बोला कि हमारे पास कोई डॉक्यूमेंट्री एविडेंस अवेलेबल नहीं है, so to show that the presence of the child in India is needed for further medical treatment. Okay, then the court actually discussed the order of Circuit Court of USA, which was passed an ex parte order because wife was present in India. She was not there, and that's why it was ex parte order, right? And the Circuit Court said that first they checked the maintainability of that particular petition filed by the respondent. The court said, yes, we do have a jurisdiction over the parties and the subject matter and venue is proper, right? Which means USA Circuit Court, they do have a jurisdiction over the parties and the subject matter. Secondly, they said defendant has removed the party's minor child to India and remained there without the consent of plaintiff. Defendant यहाँ पे wife है, ठीक है, क्योंकि यहाँ पे husband ने approach किया था circuit court को. कोर्ट ने ये बोला कि जो वाइफ है उसने फादर से माइनर चाइल्ड को अलग किया एंड उसको इंडिया में ज्यादा टाइम के लिए रखा विदाउट इवन टेकिंग द कंसेंट ऑफ द प्लेंटिफ. Then defendant has alienated the child from the plaintiff, which is harmful to the child's well-being. Okay, plaintiff is awarded primary care, custody and control of the minor child, right? And Aditya Kiran pending further orders of the court. Okay, and lastly, they said defendant shall return that child to plaintiff immediately, and hearing will be scheduled promptly upon the request by either party. So this is what the USA Circuit Court said, and the Supreme Court wanted to understand that what's their order. Now there is the counsel of the appellant, right? She submitted that there is need to make a departure from the rule of the best interest of the child or the welfare principle. All of us know that in Hindu law, when you studied, the best interest of the child or the welfare of the child is paramount consideration when it comes to the court or when it comes to the child, right? And the appellant's counsel was contending that the welfare would mean balancing the interests of all the members of the child's family. Welfare का meaning ये है कि जितने भी family members हैं उनके सबके interest को balance करना है. She also contended that the mother as the primary caregiver must be kept in mind as a person who has legal rights which must be respected and protected. So basically what happened in this case, she went into a lot of feminist reasoning, saying that this is patriarchy and the husband is always given the custody of a child and mother is neglected, her legal rights are neglected, but she should be the primary caregiver and all that. And that's why her legal rights should be respected. She means the learned counsel of the appellant, she also relied upon a decision of the court, Supreme Court in case of KS Puttaswamy versus Union of India. Okay, and she contended that the principles of autonomy must inure against non-state persons as well. Okay, and her submission is that the law regarding custody does not and cannot completely eliminate a woman in the name of child welfare. वो वही बोल रही थी बार बार कि बस चाइल्ड वेलफेयर डॉक्ट्रिन की वजह से आप कस्टडी वुमेन को नहीं देना, ये बहुत गलत है, राइट? सो इस contention पे the court said that we must note that in the case of Kanika, now they relied a lot on Kanika, this court has quoted with approval what is held in paragraph 53 of its decision in the case of Pratik Gupta. Okay. In paragraph 53 of the decision in the case of Pratik Gupta, it was held that the issue with regard to repatriation of a child has to be addressed not on a consideration of legal rights of the parties, but on the sole criteria of the welfare of the child. प्रतीक गुप्ता ने क्या बोला था, जब भी चाइल्ड की कस्टडी की बात आती है तो उसमें लीगल राइट्स को कंसिडर किया नहीं जाता, पार्टीज की लीगल राइट्स को कंसिडर किया नहीं जाता, बट सोल क्राइटेरिया क्या होता है, वेलफेयर ऑफ द चाइल्ड, राइट. देन in paragraph number 34 of its decision, that is Pratik Gupta, Supreme Court in the case of Kanika, right, Kanika को Pratik Gupta में रेफर किया था. Kanika में ये बोला था, as expounded in the recent decision of this court, the issue ought not to be decided on the basis of rights of the parties claiming custody of the minor child, but the focus should constantly remain on whether the factum of best interest of the minor child is to return to the native country or otherwise. Kanika mein, what the court said, that here we are not going to decide upon the rights of the parties who are claiming the custody of the minor child, right? But our major focus will be on the best interest of the child. What is the best interest of the child? Should she or he go to his native country, or she or he would remain in some other country, right? So child's best interest will be taken into consideration, and the legal rights of the parties claiming the custody of the minor child will not be given importance at all, right? So the fact that the minor child will have better prospects upon return to his or her native country may be a relevant aspect in a substantive proceeding for grant of custody of the minor child, but not decisive to examine the threshold issues in a habeas corpus petition. Minor child ka, the court will see that where the child will have a better prospects, right? If he returns to his native country, then he will have the bright future, or should he remain in some other country, right? This is a relevant aspect in any substantive proceeding when it comes to the grant of the custody of the minor child. But this is not decisive, or this is not important or final thing to examine the threshold issues in a habeas corpus petition. Okay, because for the habeas corpus petition, the court ought to focus on the obtaining circumstances of the minor child having been removed from the native country and taking to a place to encounter alien environment, language, custom, etc., interfering with her overall growth and grooming, and whether continuance there will be harmful. ठीक है, habeas corpus petition के लिए माइनर चाइल्ड के कस्टडी का जो एस्पेक्ट कंसिडर किया जाता है कि इफ ही रिटर्न्स टू हिज नेटिव कंट्री ही विल हैव अ बेटर फ्यूचर, दैट इज नॉट इम्पॉर्टेंट इन हेबियस कॉर्पस पेटिशन. ओके, बट हेबियस कॉर्पस पेटिशन के लिए कोर्ट को किस पे फोकस करना चाहिए? कोर्ट देखेगा कि माइनर चाइल्ड के मतलब क्या सर्कमस्टेंसेस हो सकते हैं if that child has been removed from the native country. If he has been removed from the native country, then what will be the circumstances that minor child will have to face, right? अगर आप उसे कहीं नेटिव कंट्री से बाहर लेके कोई अलग एलियन एनवायरनमेंट में लेके जा रहे हो, राइट, जहाँ पे उसकी लैंग्वेज अलग है, कस्टम अलग है, तो ये सारी चीजें उसके ओवरऑल ग्रोथ एंड डेवलपमेंट पे इम्पैक्ट कर सकती है, एंड दैट कुड बी हार्मफुल फॉर अ चाइल्ड. ओके, and this has been the consistent view of this court as restated in the recent three-judge bench decision in Nithya Anand Raghavan. So this is a 2017 judgment, an important judgment. So all these three cases related to the child's best interest in case of a habeas corpus petition. Okay, and the two-judge bench decision in Pratik Gupta, that is also a recent judgment, 2018. So it is unnecessary to multiply other decisions on the same aspect. And please repeated custody with habeas corpus. Yeah. See, why they went into this habeas corpus thing is because here the husband filed a habeas corpus in High Court. Okay. And court wanted to say that, just give me a minute. Just a second. Okay. So here the court referred to Pratik Gupta. Okay, Pratik Gupta is 2018 judgment. In Pratik Gupta, they referred Kanika judgment. Okay, so this paragraph 34 is from Kanika. In Kanika, the court, in recent judgments, they decided that issue ought not to be decided on the basis of rights of the parties. जब भी कस्टडी का माइनर की कस्टडी का इशू आता है, माइनर चाइल्ड की कस्टडी का इशू, then that issue should not be decided on the basis of the rights of the parties, because here the appellant's counsel, she was saying that the mother's legal rights are violated. Okay, legal rights means her right to autonomy, basically, right? So she's saying mother's legal rights are violated. Now here that's why court referred Kanika and said that no, the issue should not be decided on the basis of the legal rights of the parties claiming the custody of the minor child, right? But the focus should constantly remain on whether the factum of best interest of the minor child is to return to the native country or otherwise. What should be the focus? Focus should be on the fact that where does the best interest of that minor child lies, right? And that is to return to the native country or otherwise, right? तो जो minor child है, उसका best interest क्या है? Should he or she go back to his native country, or he or she should remain in an alien country, right? कोर्ट को इसके ऊपर focus करना चाहिए. It should not be about the legal rights. Now, the fact that the minor child will have a better prospects upon return to his or her native country may be a relevant aspect. Okay, तो ये जो fact है कि हाँ, अगर बच्चा minor child अगर वो अपने खुद के native country में चला जाएगा, तो he will have a better prospects, better future. So this fact may be a relevant aspect in a substantive proceeding for grant of custody, right? तो जब भी कोई issue court के सामने आता है for the grant of the custody of the minor child, then ये जो fact है कि हाँ, अगर वो अपने native country में जाएगा तो उसका better future रहेगा या better prospect रहेगा, that may be a relevant thing, but not decisive. Decisive मतलब कोई चीज आपको final करनी है, तो उसके लिए आप कुछ parameters देखते हो कि हाँ, if these parameters are satisfied, then this is something decisive for this thing. तो कोर्ट ने यही बोला कि it is relevant. It may be a relevant aspect, but it may not be a decisive factor. Why? For what? To examine the threshold issues in habeas corpus petition. Habeas corpus petition जब कोर्ट के सामने आती है, और इस केस में जब आई थी कि हस्बैंड ने बोला था कि उसने illegally detain किया है मेरे चाइल्ड को and I want him back, and that's why he asked court to issue a habeas corpus petition. But for habeas corpus petition, this fact that the minor child will have a better prospects in his native country is not a decisive factor. Habeas corpus petition, the court is saying for the purposes of habeas corpus petition, the court should have to focus on the obtaining circumstances of the minor child. Obtaining circumstances matlab, if that child has been removed or if that child, in this case, just take this case example because these are the facts of Kanika. So in this case, that child has been removed from USA, right? And USA is his native country. He's now in India, right? So, and husband has filed a habeas corpus petition. So in case of habeas corpus petition, so the court should focus on the obtaining circumstances of the minor child having been removed from the native country. मतलब आपको उसका better prospects नहीं देखना है. आपको क्या देखना है habeas corpus petition में कि उसको आपने उसके native country से निकाला है, तो वो उसकी circumstances क्या हो सकते हैं because of that. क्योंकि वो इंडिया में आया है तो उसको एलियन एनवायरनमेंट है, लैंग्वेज अलग है क्योंकि वो वहां पे पैदा हुआ था, राइट, कस्टम्स अलग है. तो ये सारी चीजें उसकी ओवरऑल डेवलपमेंट पे इम्पैक्ट कर सकती है, दैट कैन बी हार्मफुल फॉर हिम. तो हबीज कॉर्पस पिटीशन में ये डिसाइड किया जाता है. कोर्ट का फोकस ये होना चाहिए व्हेन इट कम्स टू द चाइल्ड कस्टडी एंड नॉट द बेटर प्रोस्पेक्ट्स ऑफ अ चाइल्ड. ओके, and this view is consistent with most of the judgments like Nithya Anand Raghavan 2017 and Pratik Gupta, that is versus Shilpi Gupta, that is 2018 judgment. Is it clear, Preetam? Okay. Any doubts, anyone? कोई डाउट्स है आपको तो पूछिए. Okay, thanks, Andrila. All right, so the decision of the Supreme Court in case of Kanika, right, clear, thanks, Bini, reiterates the well-settled law that the issue regarding custody of a minor child and the issue of the repatriation of the child to the native country has to be addressed on the sole criteria of the welfare of the minor and not on consideration of the legal rights of the parents. Right? तो कनिका में क्या बोला था? It basically reiterated the settled law. What is that law? That whenever it comes to the custody of a minor child, right, then the issue of this custody of the minor child to the native country, that has to be addressed only on the basis of the welfare of the minor and not on the legal rights of the parties. Then the court cited section 13 clause 1 of Hindu Minority Guardianship Act 1956. Okay, it is provided that an appointment or declaration of guardian of a minor, the welfare of the minor shall be paramount consideration. Section 13 में यही बोला है कि जब भी आपको guardian, just a second,